So thanks all for coming on this Friday morning. My name is Sarah Willey. As Rebecca said, I'm an attorney at Miller Johnson, and I specialize in employment-related issues in the workplace. I provide both counseling to lots and lots of different employers, HR folks, from all sorts of industries and different sizes of employers, and then I also spend a fair amount of my time litigating in the courtroom and handling administrative charges, etc. Right? So I get to bring to all of you knowledge based on the crazy questions that I get every day from folks like you, as well as knowledge from courtroom litigation, etc. These days, whenever I talk to clients about background checks, however, it's against the backdrop of what, guys? It's hard enough to find people that meet our qualifications. Are you serious? Now I need to have them pass background checks. Let me ask this question. How many of you have adjusted your background check processes, whether it be drug testing, whether it be criminal background checks, and otherwise, because of the lack of qualified candidates out there? Anyone? Yeah. I see that almost across the board. So recent survey, you guys are not alone if that makes you feel better, right? So you can tell your bosses it's not a problem in recruiting, right? It's a problem with regard to numbers. 84% of HR professionals say we have a lack of applicants who have the skills we need to do these jobs. This is particularly true in skilled trades, in fields like that, okay? Smaller number of applicants, lots more competition, etc. I'm hearing lots of manufacturing employers say, we're using temps, but the problem is we just keep getting the same temps, right? I'm getting lots of nods. Recycled in the door, they come, they show up, if we're lucky, for a week or a month, and then they decide, okay, I've made enough money, I don't really want to work now. They don't show up again, and then we see them in the door a month later. So that's sort of what you guys are facing. If you're not, feel fortunate, right? And the numbers are real, guys. May 2019, the unemployment rate was 3.6%. That's the lowest since December of 1969. That's remarkable, isn't it? Look how much it's even dropped from 2017. We thought it felt bad in 2017. It just continues to drop. What does that mean for you all? Well, the number of folks you have is not getting bigger, right? The pool's not getting bigger. And we're going to continue to have these difficulties in finding qualified applicants. And I'm guessing we're going to start getting a lot more creative about how we find them, creating partnerships with local trade schools, colleges, universities, etc., to find the folks we need and give them the training and experience we need. Okay? So what does that all mean for background checks? Right? Let's segue into an example here. This is based on a real life case in Michigan. You are the HR manager for a residential builder. Is anybody here actually an HR manager for a residential builder? Okay, good. Sometimes I have folks see these and think, oh my God, is this about me? No, don't worry, it's not about you. Your company has an opening for a general laborer. You conduct a background check and notice that the guy who has applied served time in prison for a violent felony, but we hire him anyway. Okay? Real life case. Unfortunately, thereafter, a subcontractor came onto the building site to meet with one of the execs who takes her meetings there. Without warning, this new hire unfortunately viciously attacks the subcontractor, and the employee was later committed to a mental institution. It's like our worst nightmare, right? Okay. Subcontractor sues your company for negligent hiring. or retention, right? In other words, subcontractor says what, guys? You knew or should have known, right, that this guy was violent, and you hired him anyway, and you put me at risk. So, what do you guys think? Should that employer be liable? So you're the plaintiff's attorney. Plaintiff's attorney says what? Employer knew this guy could be violent, had violence within him, chose to hire him anyway, right? And because they did that, they put this person at risk. Anybody want to defend the company? Yes. Okay. So defense number one says, my policy says we're allowed to hire this guy, so we're not liable. Anybody want to add? Anybody want to add? Anybody want to argue that this wasn't necessarily foreseeable for a general laborer to attack this subcontractor?
We don't know the circumstances around this.
Great. So, what, Francine, is that what you? Francine said, well, we don't really know all these circumstances, right? Right? Let's try to make this case better for the company, guys, right? All I told you is they did a criminal background check, they saw a hit and decided to hire him anyway, right? So let's say instead, you're the HR person, you wanted to foresee a situation like this, and you wanted to make sure we did the diligence that we could do in order to avoid a lawsuit like this. What might you look at or ask? Thoughts?
What was his offense?
What was his offense? Excellent. Others? Sure. Programs that he might have completed, been through. Has he had more recent issues since that conviction? Others? Yes. Absolutely. How long ago was this? What else? Anything else? Great point. Is there somebody else who's continuing to coach them, right, and to sort of guide them along? Again, we're sort of trying to better understand, was this a isolated incident several years ago, right? Or is this person truly an unpredictably violent person going forward who's a danger to everyone around him? Does that make sense? Okay. So in this case, the jury and the judge and the court were applying this legal concept, right? This is the concept that you guys are applying when you talk about what the HR rep could have done. We are supposed to use reasonable care when we hire, in other words, select folks to work in our workplace and keep them. Okay, by the way, it applies to both. When we become aware that somebody's violent and they're already employed, that matters too. To avoid selecting somebody who has a violent or vicious nature that was likely to result in injury to somebody. So this is all about what? What is reasonable care? Not only can we, but we should follow up and do this reasonable care to learn more information. Absolutely, those are all fair questions, okay? So that's the obligation to use reasonable care. In that case, the jury found for that subcontractor. In other words, the jury said that employer should be on the hook, okay? The average person thought, well, I don't like these facts. I think this employer should have done more than just done the background check and hired him anyway, okay? But actually it got appealed all the way up to the Michigan Supreme Court, and you might be surprised to hear what they said. They said just because somebody has a criminal conviction does not mean that we can assume now and forever that they are violent, right? And could randomly attack people like that subcontractor. So that's not fair to put that on the employer in that case. Is anybody surprised to hear that? I think so, because not a lot of folks took that position, right? But that is what the Michigan Supreme Court has said. In other words, the Michigan courts give employers more freedom than you might realize in making hiring decisions. Okay? Now, of course, when we're making hiring decisions, we're not worried just about getting sued for hiring the wrong people, right? Our primary objective is what? Yeah, first of all, hiring folks who are going to show up and do the job, right? Which can be more challenging than we would like to admit, right? And keeping those in our workplace safe, right? So of course, we're going to engage in more reasonable care probably than the Michigan Supreme Court says we have to, right? But I do think it's important to dispel that assumption or that notion that we are legally responsible whenever an employee does something crazy or unexpected in our workplace, because we are supposed to be able to see the future and know what folks are going to do. Okay? All right, so that is my introduction to get our juices flowing about background checks in general. We're going to talk not only about criminal background checks today, guys. We're going to talk about sources of background information. We're going to talk about when we do them. That gets back to, do we ask about this stuff during the interview or otherwise? We're going to talk about medical information. We're going to talk about criminal background checks. We're going to talk about the Fair Credit Reporting Act. And we're going to talk about employment references. You guys ready? Right, so Al said, question about the case. Did that person only have one conviction? Is that what you were saying? Yeah. Yes, that's the fact. Yes, that person had been convicted of one violent felony and had gone to prison for it.
And how long?
I can't remember the duration of time that had passed. I think the crime itself had been a bit before, but the gap between when they got out of prison and was hired was not particularly long. Does that make sense? Okay, so just a minute about how do we gather information to help us hire the right people? What do we look at? Okay. First one, right, is relatively new. How many of you guys do this? Look at Facebook, internet, Twitter. How many of you regret it? Yes. Think, oh, you kidding? Yeah. This is sort of a funny story. I'm not even sure. Well, I'll tell you this story. Probably 10 years ago at Miller Johnson, we had a young attorney, fairly recently out of law school, who had all the credentials, right? And presented extremely well. Came in and interviewed, and everyone was impressed, talked to like the big partners in the firm, etc. While he was there are emails going back and forth. Should we make him an offer? Yeah, let's make him an offer before he leaves. We got to get this guy, etc. And then somebody happened to notice that on the bottom of his resume, he included a Facebook page. Okay? This is back when people in their 20s used Facebook. I think only we use Facebook now, from what I understand from my kids, but only the old people use Facebook, right? But indeed, he included a Facebook page, and that attorney thought, let me see. Pulled up the Facebook page, and there is this guy smoking a bong with, I don't know what you call it, with the three people are smoking a bong all together, and you scroll through and there's all sorts of pictures of him partying, I don't know, with the fraternity or whatever, et cetera, et cetera, et cetera. The emails changed. Internally, he did not get an offer out the door, and the going consensus was, I'm less concerned about maybe the smoking of pot while this guy was in college. It's more the stupidity of putting your Facebook page on your resume, right? So that was that. Anyway, we can, right, in Michigan, there are no restrictions on our ability to go on to applicants' social media, whatever that social media is at that time, because it's constantly changing, right? Facebook, Twitter, etc., to do intel about them, what they like to do, whether they smoke bongs or not, etc., right? I should warn you, there are some states that do have laws that limit an employer's ability to do this. So if you operate in states outside of Michigan, that's something you need to keep an eye on. And that, of course, is an area that's going to continue to evolve, right? So keep an eye on that. I think that social media, my opinion is it's about as good as a personal reference as you're probably going to get, right? What's the risk? What's the downside, guys? Any thoughts? If you haven't seen this person yet, right, all you have is a piece of paper describing where they went to school and their previous employment, right? What is social media going to tell you? Who they are? All sorts of protected classes, right? Race, disability status, gender, age, maybe religion, etc., right? Okay? So one risk is we get that knowledge of protected classes that we're generally coached not to have when we're sorting through employment applications, right? In other words, there's a reason we don't put on an employment application, how old are you and what's your race and what's your religion? And the reason is we don't want to be accused of having those be deciding factors, right? So when we go on social media, that opens up that world to us, okay? Pros and cons of doing that. What else? For certain positions, of course, licensing and certification records are things we look at. Public records, that's usually criminal background checks that are publicly available. Also, the sex offender list. I have lots of employers looking on SOAR. Credit checks, references from previous employers, and personal references. How about when? When do we ask for what information?
We have to have an offer.
Right, so Anne says, I think you should have to have an offer. Does anybody do it differently? Okay, I see a bit of a tension here, to be honest, and I hear HR folks arguing this different ways, right? Some HR folks would say, well, I'd rather do a basic background check before I interview them and before I've made them an offer, because if there's something clearly exclusionary, I'd rather know, right? I'd rather know now before I tell other candidates that they don't have the job, right? Before I go through all the process of interviewing them and offering it to them, I'd rather know sooner, okay? Why would we wait until after? You guys are like, I don't know, that's just what I was told we have to do, right? The reason that we usually, the practice is generally to wait until after is because for a lot of these background checks, we have to ask information that elicits, again, those protected classes, right? Date of birth, race, is sometimes required, right? But we're not supposed to consider any of those things in the hiring process. So again, once that becomes part of our knowledge, then an individual has the ability to argue, oh, the reason you didn't hire me is because of my age, right? We would prefer to be in a position to say, I didn't even know your age. How could that have been a factor, right? So that's why many employers wait until after a decision has been made before they ask for this information and then run the background checks. Does that make sense to everybody? So the solution to that problem is you wait until you make an offer. And then of course, when you ask for age and race and all that stuff that you need to run a background check, then you explain to them, this is why we're asking for it, okay? Absolutely, you make your offer contingent upon the passing of the background checks. And let me just add something that I think is very important, and that is, if you also do any sort of a pre-employment medical exam, right? That has to be done after an offer has been made. And this is really important, guys, it has to be the very last hurdle that person crosses in order to get hired, okay? So they should have passed all of these other background checks before you send them for that pre-employment physical. That seems like a real technicality, but I've actually had employers get that wrong and get sued over it, okay? Because they made an employment decision too early based on a pre-employment physical. So it's got to be the very last thing. Yep. So a DOT driver who are required, say that again, who are required to have a medical cert. Right. So are you saying you just require them to present a copy of their medical cert? That's different from making them go get a medical exam.
Okay.
Does that make sense? So that's a qualification, right? That's a qualification for the job. You have to have the medical cert. It's fine to confirm that they have the medical cert. Yes, you can. But if you want to send them for your own pre-employment physical to learn information about their physical ability to otherwise do the job, that's different. That's a medical examination we are requiring as the employer. Right, let's just dive right into the ADA, right? Let me repeat this back succinctly first so that everybody has it, and then I'll answer your question. So the question summarized is, we have somebody, we make an offer to them for a receptionist position. At the pre-employment physical, we find out that they're actually hearing impaired and have cochlear implants, right? So what do we do about that if we've hired them for a receptionist job? So just quickly, I love the ADA. I don't know, I spoke about the FMLA and ADA this spring, so I'm happy to dive into this, but we're gonna be quick about it, right? When we have a situation like that, guys, what are we evaluating under the ADA? What's the question we need to answer? Ah, yes, right? I heard mumblings of essential functions, right? Essential functions, that's exactly right. So the question we are facing is, okay, this person has a disability, fine. Are they qualified to do this job? In other words, can they perform the essential functions of the receptionist position? And, there's an and, do they need what? Any reasonable accommodation to do it. So in a situation like that, you will get that information from a pre-employment physical back, and then we're gonna be doing some work to number one, lay out, okay, what are the essential functions of this job? Can this person with this impairment do those essential functions? Can they do them? Can they hear on the phone? Can they take all of this information on the phone? And if the answer is currently no, is there any sort of equipment or accommodation that we could make for that person so that they could? Does that make sense? I make it sound so easy, right? And then in the moment you're like, oh my God, what do I do? But yeah, that's the analysis. Okay, Let's go back to medical inquiries, right? So the rule of thumb is that we can't ask any health information until an offer of employment has been made, okay? So examples of things that I've seen employers ask, even on an employment application or during an interview, that are no-nos, right? Do you have any impairments that would interfere with your ability to perform the job for which you are applying? What's wrong with that question? It's essentially asking, what? Do you have a disability? Sort of like saying, what's your race, what's your age, what's your religion, right? Do you have a disability? What's a better question? Yes, Anne, that's so good. Can you perform the essential functions of the job? And quite frankly, that's just bad writing, because that's really what the employer wanted to know. Can you do this job or not, right? What medications are you currently taking? Don't ask that question. What other bad questions? Please check in the space provided if you have any of the following conditions or impairments with a list. Okay, full disclosure, that was a while ago that I saw that employment application, but it's still, right? And sometimes I have the opportunity to review personnel files for folks who have worked at an organization for a long time, right? So I get my hands on an employment application from like the 70s or 80s. That's awesome. They have lots of things like that. We were so naive back then, right? Have you ever claimed or received workers' comp benefits? Right? How much time off are you going to need for a health condition? How many days were you sick last year? Okay? How many days were you sick? But you can ask, how many days were you absent last year? Okay? Again, I think that's really what you want to know anyway. Are you going to come to work on a regular and predictable basis? How much alcohol do you drink each week? What can we ask? Oh goodness, that list is so much shorter, isn't it, than what we can't ask. Sorry. Are you able to perform the tasks and functions of this job? Can you meet the attendance requirements of this job? Have you used illegal drugs in the last number of years? Those are all fair questions. All fair questions. Okay. Now, the one time that we might get into medical inquiries for an applicant is if they ask for an accommodation during the application process. Has anybody ever had that? No? Okay, sometimes applicants say, I have a disability, I'm deaf, I have a physical disability, etc., right? And so during the interview, I need X. I'm asking for X. When that occurs, we actually do have the ability to inquire further about their health condition, try to figure out if it's a disability under the ADA, and try to figure out our obligations to provide reasonable accommodation. But that's only when they first disclose that, and it's in the context of requesting an accommodation. Fairly unusual, as you can tell from the lack of hands. Yes? Oh, great question. So I'll repeat the question back. When an applicant self-discloses health or medical information during the interview that you have not sought and frankly probably isn't even relevant to the job, right? How should we respond to that, and should we document that? What do you guys think? Don't write it down. Pretend it never happened, right? Let's take the first one first. What's a good response to that, guys? How do we redirect that? Sure. Do you think this is going to affect your ability to do your job? Or even, right? Let's talk instead about what this job requires and whether you can do it. Right? Sort of take them away from let's stop talking about, right, whatever it is you're sharing, And we'd like to focus instead about what this job is all about and whether you think you'd be successful in this role. That's how I would respond, okay? I actually would document that we responded in that way because I'm really cynical. And sometimes people do that, why? Yes, to kind of set you up. I know, I'm so jaded and cynical, it's terrible, but I've been doing this for long enough that sometimes that's the case, okay? So I would document that they self-disclosed a health issue and here was our response, right? And that's enough. So that if later they came back and told a different story, we've got a summary of what was actually said that we can rely upon. Just a reminder that under the ADA, any medical information we obtain has to be kept in a file separate from their personnel file. Okay, now we're getting more into the heart of things here. Let's talk about criminal history checks. How many of you do them? Okay, I don't know. Seems like less than half. It was hard to get a good read, right? Are still doing criminal history checks. How many of you have changed the types of convictions that are exclusionary within the last 5 years? Okay, what'd you guys change? What'd you change, Ann? Good. So I think what Ann said is we've shifted away from any sort of automatic exclusion to, okay, if there's a hit, what that means then is we're going to have some further conversation and do our reasonable process, right, to try to figure out whether this person should be in our workplace or not. Other thoughts on that? For those doing criminal background checks, are you generally following a process like that? Or is there still a list of things that are exclusionary across the board? Just curious. There are some that are just exclusionary across the board, like what? Yes. So it works for a construction company, so we'd be looking for convictions of theft, breaking and entering, etc. That's going to be a concern for us, right? And why is that, guys? Putting the pieces together. It's right, we can see that connection, we can see that foreseeability, right, of maybe that person breaking into homes, right, that have been constructed, they have access to them, etc. And so we'd be looking at the safety of others and maybe also protecting our own property, right? Okay. All right, so how do we do criminal history reports? How many of you directly use iChat or another state of Michigan resource? Few hands, okay? Few hands. So there's one with the Department of Corrections, and then there's also iChat, right? First thing I'll say and warn you of is neither of them are perfect. They all have mistakes, okay? So you have to keep that in mind. I've seen lots of them, right? I've seen things on there that aren't true. I've seen things on there that were supposed to be expunged and are still on there, etc. So bear that in mind when you pull these up. They are not 100% accurate. The iChat tool, I think, is the most accurate. And I like it because it gives information about their arrest. So it shows the circumstances under which they were arrested, and then it shows what they were charged with, and then it shows whether they were convicted, and if so, what crime they were convicted of. And it tells you whether they pled or not. Okay, so it gives you a larger story to understand. You can sort of see, okay, they got arrested on this, right? Then it got charged as something else, and then they pled down to a misdemeanor. So we'll often see they got arrested on a felony, they got charged with a felony, and then they pled down to a misdemeanor conviction, and that's how that worked, okay? Doesn't tell you the whole story, but it gives you a bigger picture. Those are $10, and anybody can have access to them, and you don't have to have the individual's permission. You all could go and run one on me right now if you wanted. There's nothing on there, right? We do, nonetheless, recommend that our employment application tell applicants that we are running criminal background checks if we are going to do it, and getting their authorization to do so, okay? Now, bear in mind too that different states have different laws about the requirements of getting authorizations for background checks. Michigan does not require it. Lots of other states do require authorization, yes. So the question is, if we put it on the application that we're going to do the background check and we'll need certain information in order to do it, is your question, can you later ask for that information? I would not recommend, again, I wouldn't recommend asking the demographic information on the application, because that is not information you want to have at that stage in the process, right? Mostly because then you've opened the door for them to say you didn't hire me because of my age or my race. You asked me to disclose it on the application, and now I didn't get an offer, right? So the better practice would be to tell them on the application we're doing the background check, get the authorization for it, and then after, when and if they're qualified and you make an offer of employment, then you ask that information. Well, that's just it, right? So the state of Michigan doesn't require authorization, right? But if you are going to require them to give you information so you can do a background check, I think you want to know when they apply if they're not going to authorize you, if they're not going to give it to you, right? That's why I say I would put it on the application. If you are going to require a criminal background check, I would tell them that on the application so they are aware of it, right? And I would include an authorization in which they say you're allowed to do it. That way, if that's a deal breaker for folks, right? They know at the front end. They're not gonna waste their time, and we're not gonna waste ours. Now, I'm gonna talk in a minute about ban the box, okay? So, taking it one step further, many employers are following a practice of also saying to folks, we're gonna do a criminal background check, but just so you know, we can sit right, having a felony or having a conviction doesn't automatically exclude you from working here. Here are the things we look at in order to make that decision. Okay, and I'll explain to you in a minute about why you'd want to say that. So this is an example of an iChat report. See how it shows the arrest segment, right? So they got arrested on a misdemeanor traffic offense, and you think, what's that about? And then you get a little bit more information with the charge segment, right? And you learn what? Operating while intoxicated. And then on the judicial segment is where it explains whether they were convicted or not. And what that tells us is they were convicted of a misdemeanor of operating while impaired, and they were found guilty, which means what? That actually got tried in front of a jury, right? So they felt strongly enough that they hadn't done anything wrong that they took it in front of a jury. In other words, they did not plead guilty in that case. That got tried in front of a jury. They come up immediately. Yeah. Not everything is loaded immediately. In other words, you will get the results immediately on your computer, but they may have gotten convicted on Tuesday. It may not be on there yet.
Will it show up later then?
Yes, it will show up later. Oh, such a good question. So the question is, if we do, let's say criminal, right? Let's make it a more salacious question. If we do criminal background checks, do we have to do it on everyone, or can we pick and choose? Thoughts? What makes you cringe to say everyone, guys? Say it again. I'm not going to run it on my president, right? Or CEO, because God forbid it comes up with something like that.
You better run it on your CFO.
Yes, you better run it on your CFOs, which gets more to the bottom of the question. But why did everyone's gut say we have to do it on everyone? Because you're worried about that D word, right? Discrimination, right? So if we pick and choose who we run it on, are we going to get in discrimination issues? And I would say yes, but let me split hairs with you for a minute about that. I think if you pick and choose who, that's problematic. I think if you select what positions, that is not. And maybe that's what you meant by your question. You can absolutely say, we are going to run background checks on our CFO and everyone in our accounting department, but maybe we are not going to with regard to our HR people. No, just kidding. With regard to our production employees. Okay, I'm not saying that, I'm not recommending, right? I'm just saying you could draw those lines based on job position, and quite frankly, that often makes a whole lot of sense to do that, right? And of course, you can also say certain convictions are more relevant for some positions rather than others. Okay, so let's go back to be aware that in Michigan, under the Elliott-Larsen Civil Rights Act, okay, we cannot by law make any employment decision based on a pending misdemeanor charge. Okay, so go back to that report. If you see a misdemeanor under arrest and charge, but either the judicial segment is blank because they haven't been convicted yet, or it says they did not get convicted. Let's pretend that said found not guilty. We cannot make any employment decision based on that if it's a misdemeanor. If it's a felony, believe it or not, we can. We can say, we're not going to hire you because you got arrested on a felony. We don't really care if you got convicted of it or not. I don't see a lot of employers actually doing that, but you can. Again, bear in mind, this is a state law issue. All states have different laws about what convictions and arrests can be used in the hiring and employment process, okay? The last thing I'll say about that, by the way, is this Elliott-Larsen law often comes up less in hiring than it does with current employees who we found out just got arrested on some charge, right? And then we're trying to figure out what to do about that. A driver just got arrested on a misdemeanor drunk driving charge. What are we supposed to do? We know it's a misdemeanor that hasn't resulted in a conviction, yet we've got concerns about whether or not they should be driving for us right now. Great question. The question was, are our current employees supposed to disclose it, right? I think you're asking about current employees. If we tell them they have to, the answer is yes. Also, there are some laws for certain employees like teachers, right, that do affirmatively require them to disclose it. But for the most part, most employees are not under a legal obligation to disclose arrests or convictions during employment. Many employers tell them, though, you have to tell us within 77 days if you get arrested or convicted, et cetera. Yep. Yeah. So the question is, what can you ask on the application about convictions, right? Okay, so the proper question is, have you ever been convicted of a misdemeanor or felony? Is fair, right? You could also ask, have you ever been convicted of a misdemeanor, right? Or arrested or convicted of a felony? Does that make sense? The most common question is, have you ever been convicted of a crime, or have you ever been convicted of a misdemeanor or felony? Okay, which is a great segue to ban the box. Yes, question. Okay, great question. We've got drivers, right? Some of them drive our vehicles, some of them drive their own. Can we check driving records? Absolutely. Insurance company says you need their permission, so just get it on the application. Been there 20 years and you say we need a copy of your driving record because our insurance company requires it. To me, that's a qualification for the job. In other words, to be a driver, to particularly, well, let's take that apart, right? To drive our own vehicles, we have to get them insured. And if they're going to stand in the way of us getting them insured, unfortunately, they can't drive our vehicle. To me, that's a fairly simple. You can still have that qualification that if you are going to drive your own car during work for your job, right? You have to have a driving record that's acceptable, and you have to let us check your driving record in order to do it. That's lawful to make them require it. It gets a little bit more complicated when you have an employee that's been there for 20 years and how you fight that battle, right? And they don't want to let you. Of course, what are you guys thinking when you hear this story? I think I want to see it more than ever. Right? And you may see, I mean, I've got lots of stories about employees, as it turns out, have a suspended license and they shouldn't have been driving at all. And they've never told you that. Yeah, is this stuff in the handbook? I see lots of driving by this stuff. Do you mean the authorizations to do these checks? You can put it in the handbook. That's not the best place for it because the handbook also says all over the place that it's not a what? Contract, right? Now, I write handbooks usually so that they say they're not a contract except for a contractual section in the handbook. Sort of a fancy way to do it, and then that's a great place to put that. Also in the contractual section, I put confidentiality agreement if we want to have that. I put limitations on claims, et cetera, et cetera, et cetera. Okay? Okay, let's talk about ban the box. Who's heard this term? What does it mean? What's the box? Yeah, so it's referring to the question on the employment application that asks, have you been convicted of a crime? Right? And there's a recent push, right, to encourage employers to ban the box or not ask that question, okay? Many states have passed laws banning the box, have passed laws saying, look, don't ask on the application, give everybody a fair chance to apply, right? Look at their qualifications, meet them at the interview, then do the criminal background check and decide whether this person should be in your workplace or not, okay? The EEOC is largely behind this as well, okay? And from a legal standpoint, let me explain a little bit more what sort of prompted this push for ban the box. I think it's probably been about 10 years now since the EEOC published a guidance that said, we think outright exclusionary criminal background checks, in other words, an employer saying you can't have been convicted of a crime to work here, we think they have what's called a disparate impact on certain races and genders, i.e. African American men, right? And guess what? They're exactly right. Because statistically, for lots of reasons that we are not going to get into today, okay, if statistically African American men are arrested and convicted of crimes at an alarmingly higher rate, than white men and certainly white women. Does that make sense? So if we apply that rule, what does that mean then? Right? We are going to exclude African American men at a higher rate, okay? So that started this push toward, okay, well then we should probably be looking at things deeper than that, right? And maybe we shouldn't be carving out a huge segment of our population at the employment application, because when we ask the question, that sends the message to those individuals who are applying what? We're not going to hire you. Okay? So that's what's driving this. Okay? There was a federal law that would have prohibited inquiries about felony convictions. That did not pass, but many, many states, cities, counties have passed ban-the-box laws. Okay? Examples. And the requirements are just all across the board. Okay? Some of them say, okay, you can ask, but you've got to have that affirmative statement saying, don't worry, it's not exclusionary, we look at other things, right? Some impose different rules, et cetera, et cetera, et cetera. Examples: in New Jersey, in Illinois, employers cannot ask any question regarding criminal history at the initial application stage. 0. California has a similar rule too, okay? In Indiana, does anybody do business in Indiana? Right? Did you know if somebody has a criminal record that's been restricted or sealed, they can legally deny having a record on the application, right? And the employer cannot ask. So we need to ask that question differently on our Indiana application than we do on our Michigan application. And again, these state laws are going to continue to evolve. Okay, so keep a careful eye on that if you're operating in states other than Michigan. The EEOC's position, as I mentioned, is that if we consider criminal convictions to be exclusionary, that has a disparate impact, okay, that is discriminatory, okay? And so if you want to do that, employers, okay, you need to offset that by taking a time out, and rather than automatically excluding those folks from consideration for employment, we need to think about whether consideration of the conviction is related to the job and whether it's necessary for our business, right? So who has an example of a crime that's not related to a job? Yeah, great. That's almost always the example I get. A production employee has a DUI, but otherwise still has a driver's license and can get to and from work. Do we care? Generally not, right? So long as they're sober at work and they can get themselves to and from work, okay? What's one that's clearly relevant to a job position? Criminal sexual conduct offense in a teacher. Sure, Michigan state law would say, yeah, you can't teach. Others? Embezzlement, that's always the example I get, embezzlement for your CFO, right? Okay, so we've got both ends of the spectrum, right? And almost everything else is there in the middle, right? And that's where you guys are living, trying to figure out, okay, here's the conviction I'm seeing. Is this relevant to this job or not? Okay, the two types of offenses that I see employers consider and struggle with the most are any violence or quasi-violence, right? Even for a production, does it matter if a production employee was convicted of felony assault, right? And some will say, yes, it does, because you need to work in a space that's very close to lots of different people, and plus you have heavy tools, right? And you might throw them at somebody's head, because that happens, I can tell you. Okay. Would that be automatically exclusionary, or would you want to look at other factors?
I think I would look at the record.
You'd look at the record, you'd want to know what the length of time, what the circumstances were, right? Did this person find out their wife had been cheating on them and beat the crap out of the woman who was, or the guy who was sleeping with his wife? Or woman, I suppose, right? Etc. Okay? EEOC, and now even momentum in our public space is discouraging automatic exclusions, but for those on that end of the spectrum, the embezzlement for the CFO, right? All those in the middle, I would say most employers are living in a land of, okay, I'm gonna look more closely at the circumstances in the job to think about it and decide if this is really relevant to the job or not, okay? Things you should look at, the nature and gravity of the offense, right? There's always facts and a story behind it. Get them from that person, how much time has passed, and then of course the nature of the job that they're applying for. Last week I had a question about an individual who's getting hired for a job that worked solely from home, right? And had been convicted of, it was a misdemeanor felon, or it was a misdemeanor assault or something like that. That's kind of hard to make that connection, isn't it? Why it matters, okay? The EEOC's recommendations are here. I think it's helpful to see. They say, first, tell folks what you found. Second, get that information from them. Give them an opportunity to explain, and then take a look at it, right? And sometimes I can tell you, you will find that person will say, I don't know what you're talking about. I've never been convicted of anything in my life, right? And you say, well then, what are we gonna do about this, right? You gotta figure out how to get this off your record because it's pulling it up. I had a situation in which somebody had been wondering for a lot of years why they couldn't get hired. And nobody had ever said to them, you have this conviction on your record that they should not have had. Okay? Questions on the criminal piece. A background check company called CenturyLink. I don't know them in particular, but there's a million companies that do background checks for you. It's actually a good segue into the Fair Credit Reporting Act. So hold that thought. Yes. Right. What if they lied on the application and said, I've never been convicted? Right. So many employers would say, well, we're not going to hire you because you lied on the application. And I'll say, up until about 5 years ago, that was sort of the HR standard across the board, right? Don't focus on what the conviction is. Don't worry about that. If they lied on the application, just don't hire them because they lied on the application. With Ban the Box, there's a lot more sensitivity about that now, right? And sort of this understanding of okay, well, if somebody has a conviction on their record and they've been trying to get hired for the last 10 years, should we forgive them from lying on the application because what they've learned is if they tell the truth, they'd never get a shot. Which again, sort of dovetails into Ban the Box. Does that make sense? Okay. From a legal standpoint, you can still say, we're not going to hire you because you lied on your application. From a sort of where the world is heading standpoint, I think HR is going to begin to think about that maybe differently going into the future. Yep, one more question, then we'll move on to, you guys just don't want to talk about the Fair Credit Reporting Act, I think. It's really fun and interesting. Yep, happens all the time. So the question is, we don't do any upon hire, but our customer says you have to run background checks. Okay, so the question is what? Do we have to? Can we? Right, so then guess what? You have somebody that doesn't pass Customer says they can't work on that project. What do we do with that person, right? Well, the first thing I would ask is there other work for them to do? I guess I would presume from your question that this is an employee that's been otherwise successful, right? And hasn't had issues in the workplace, right? So they've got this X on their record, but you hired them and they've been doing well, right? So from an HR standpoint, also in the context of us not being able to hire enough qualified people, you're thinking, God, I'd really prefer not to fire them over this. They're otherwise a good employee, right? So number one, though, now you're on notice of this thing, right? So you do have to think about that negligent hiring piece. How bad is it? And is it relevant to their job with you? If you think it's still okay to keep them employed, I would look at whether you otherwise have work for them. If unfortunately you just don't, you simply don't, then your hands are tied, right? Unless you can get the customer to agree to let them do the work. Okay, Fair Credit Reporting Act. Fair Credit Reporting Act is in play whenever you use any third party to gather information about an employee or an applicant. So anytime you are not doing that work yourself, you are in the land of the Fair Credit Reporting Act. Lots and lots and lots of employers and HR folks don't realize that. Notwithstanding the name of the law, credit, it does not only apply to credit checks. I'm talking about using a third party to do any background check, such as criminal history checks, etc. Okay? And what it does is essentially just create really annoying procedural requirements that we have to follow. And if we don't read the back of the Monopoly box closely enough and don't follow those requirements, then we can get sued for it. Okay? You can avoid this altogether if you just do the background checks directly yourself, by the way. Okay? If you use a third party under the act called a consumer reporting agency, then you have to comply. Okay? So just for example, you can go on to iChat yourself and get criminal history, right? The Fair Credit Reporting Act does not apply to that because you went on to that source yourself and you got it directly. If you hired one of those third-party background check companies, the example the woman in the back just gave, then you will have to comply. Skip through that. So what are the requirements? Number one, before we can do any check, we have to notify them in writing and get their authorization for it. This has to be a separate document. It cannot be part of the employment application. Has to be completely separate. Okay, so number one, you've got to get their consent. Number two, if something comes up, you have to give them what's called a pre-adverse action notice, telling them, hey, something came up, this could result in us not hiring you, and that has to include a summary of your rights under the Fair Credit Reporting Act. By the way, all of these notices are available online from the FTC, Federal Trade Commission, and we have them too at Miller Johnson, okay? And then finally, after you take adverse action, i.e. not hire them or fire them because you got this information, you have to give them a notice that has these very certain and distinct things on them. And they have 60 days to dispute the report. Okay, so they can say, I was never convicted of this crime, this is wrong, this thing on my credit report shouldn't be there, I don't know what that is, et cetera, et cetera, et cetera. Okay? An example of an actual case coming from an employer not following these requirements. Hold on one second. Grand Rapids area employer, yikes, right here, right? It feels a little close to home, was sued in federal court because it did not hire a temp for a permanent position because his background check disclosed a felony conviction. Guess what? They used a third party. The background check was wrong. The employer didn't comply with the Fair Credit Reporting Act, and they have liability there under the Fair Credit Reporting Act for that failure to hire that individual. Question. So she says, I'm thinking I don't want to use CenturyLink anymore. I would get in contact with CenturyLink and try to understand what parts of this they're doing, right? But also they are supposed to be giving you certain notices under the Fair Credit Reporting Act too. Okay, so I'd maybe do a little intel and try to understand what their compliance plan is with the Fair Credit Reporting Act before you panic. Yeah, so they might, the comment is they might be following. Now, whether they're getting that initial authorization correctly is a whole different story. Usually not. Usually they're assuming you are, and maybe you have it on an employment application and it's not that separate, correct notice that technically complies with the act. Okay, employment references, okay? These are we get phone calls, right, from a prospective employer about somebody, or we are looking for information about somebody's employment. How many even do these anymore? One. Yeah, what wonderful information do you typically get? You could get an old farmer who will tell you this person's life story and have no understanding of why they may get sued for it, right? Yep. Yes, data, when did they work here? What was their position? What was their pay, etc.? Are they eligible for rehire or not? And that's, I'm guessing, probably what you guys generally give out. For that reason, employment references have become not real useful, okay? Let me just take a minute to dispel the myth here, right? You guys, everybody's afraid of saying anything because they're afraid of getting sued for defamation, for saying things that aren't true. In Michigan, though, did you know you have immunity from that? So there is qualified immunity to disclose information relating to an individual's job performance if it's documented in the personnel file. So you can't get sued for it unless that person can show you said something that you knew was not true, right? Or you had a reckless disregard, blah, 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 okay? So you can probably say more than you realize, okay, about a former employee. And the same is true for folks you're looking to hire, okay? I do see employers have a little bit more success with these if they get that authorization to contact that current or former employer. Again, we can get that on the application. And that person signs a release, right? So you send it to the former employer and say, they've actually authorized me to talk to you a little bit more about their employment history. So can you share that? Now, also, this process is very helpful in that it does kind of bear out what probably happened at their last job by their reaction when you ask for their authorization to talk to their former employer, right? I mean, a lot of this is asking questions and reading between the lines when you get the response. Kind of like when you call for a reference and you get the date of hire, the position, the pay, and you say, can you tell me whether this person is eligible for rehire, right? And there's a long, awkward silence. Your question has been answered. You don't know everything, but you know what? There may have been some concerns, right? At the same time, if they jump all over it and say, we'd love to have her back, she was the best employee ever, right? That gives you a lot more information too. bear in mind that Bullard-Plewicki does restrict any employer from disclosing disciplinary information without first giving notice to that employee. So again, that's another reason to get that authorization and release for you to reach out to former employers. And that should be part of that. That language should be in there. So if you've ever read that a lawyer wrote and it says, including any information protected under the Bullard-Plewicki Right to Know Act, that's why that's in there. Okay? Lastly, just additional things, personal references. I think these are traditionally underrated because somebody can pick who gives them, like their mom, right? Or whoever. They can be useful though if you ask good questions, right? If you ask the right questions and you think it through. And then sometimes we're also looking at educational records and licensing and certification records. I will warn you, with the internet becoming more and more prevalent, I'm seeing just a ton of fraudulent diplomas and educational records. So tread carefully there. I'm getting nods from folks like, yeah, I know what you're talking about there. So that is all I have for you today. Thank you for the discussion.